I have 10 minutes, so it's quite difficult. Jean-Yves asked me to speak about European administrative law, but 10 minutes it's quite a little time. So how I will use this 10 minutes? I was thinking first to give you perhaps some overview of not only the Article 41, but also other law, let's say, or not law, soft law, the basis for our work, which is certainly good administration. And then I would like to speak a little bit about our cuisine, how problems look like when we deal with these issues of good administration with the European institutions and bodies. And finally, I would like also to mention some cases which are having now in the office concerning exactly asylum migration issues. So first I will start about this right to good administration. You know, the European Ombudsman on many occasions is called to be a guardian of good administration. Perhaps it's too much to say, but on the other hand, we have, on the basis of Treaty Article 228, we have the obligation to deal with cases concerning complaints, concerning instances of maladministration. So we have on one side the good administration, which is brilliantly Luke explained it to us, Article 49 of the Charter, set up the right to good administration, which is of course open-ended article, but for our discussion today we have three elements which are important from the Article 41, namely right to be heard, namely statement of reasons, that's my obligation to provide reasons for administrative decisions, but also fairness, because a fair decision-making process is essential, and in the Ombudsman work we rely a lot on fairness, because fairness could be, you know, quite elastic terms into which we could put also some issues concerning natural justice even, which is sometimes difficult to convince the European administration that this aspect of decision making is also important. So we have Article 41 of the Charter providing for the right of to good administration, and thus the obligation of the European administration to comply with these rights. But we have also other instruments which are soft law, but extremely important for our work as a controller of European administration, namely European Code of Good Administrative Behavior. I don't know if you never heard about this instrument, but it was adopted in 2001 by a Parliament in the form of a resolution. This was a project of the then Ombudsman Jakob Söderman, the first European Ombudsman. And this is kind of guidelines. It is kind of how to put into practical terms Article 41 of the Charter. The European Code of Good Administrative Behavior has 27 articles. I encourage you to go on the website of the European Ombudsman or even in Google and see the content, because these articles, they are really very practical indication for European administration how to comply with Article 41 of the Charter. So if you go, for instance, to the issue of statement of reasons, or individual statement of reasons, we have some indication, for instance, whether there is a need to submit written observation to and the decision which should be issued against a concrete person, whether if there are no written observations, this would be considered as compliance with right to be heard, etc. So European Code of Good Administrative Behavior being soft law, but still very important for the control of European administration in terms of Article 41 of the Charter. Then we have the work of the renewal, which was mentioned by Jean-Yves. The European Ombudsman was behind the renewal, so I am the member of the organization of this research network. This is the research network on European administrative law, existing from 2009, and the first 5 years of the existence of this network was about how the European administrative law, which doesn't exist as such, could look like, how to codify the many principles and rules here and there in one legal instrument. And as a result, in 2014, Renewal published a model draft of European administrative law. This is a very interesting document. The book 3, which would be the most interesting for us today, is about decision-making process. And then you have procedural rights stipulated as regards, once again, right to be heard, individual assessment or general assessment of the legal and factual situations. Then you have statement of reasons developed and the entire plethora of procedural rights. This work would have no sense, let's say, if Parliament would not have followed it. In 2016, in June, European Parliament adopted a resolution and a draft regulation for European administrative law. This is also an interesting document, starting from 2016 until now. Nothing happened in this direction, but even if Parliament had to take into consideration, let's say, the political acceptability of this regulation, so this is much less ambitious than the document we elaborated in the network, in the renewal, but still is a very interesting also to read this procedural rights part, which also again put into practice what Article 41 of the Charter means. Here I will just perhaps end by saying that the regulation, if one day it comes into force, hopefully this will be adopted and we will have European administrative law, this will apply only to European administration, so not to the member states. And today we rather discuss about decisions of the member states. But still, this could have some value for interpretation at the national level of administrative law. Also, the regulation would not apply to specific, let's say, rules or situations which are regulated by other regulations, but we be providing against like lex generalis and lex specialis relationship. But this is also a very important document, this 2016 Parliament draft, which we hope will see one day, we will see really the codified European administrative law. After all this small introduction, now a few words about what are our issues with cases when we deal with European administration. Well, so we speak about individual assessment. Individual assessment, as Rick explained it, we have right to be heard and statement of reasons which could be general, but rather should be individual. We have, of course, case law of the European Courts of European Court, starting from Technische Universität München, but also quite recently unreturned issues in case of Makarubega, in which the court stated statement of reasons should be specific, individual, but we hear on many occasions from the institutions that no, they cannot make individual statement of reasons for a specific administrative decision because there are many cases of the same kind. They don't have, let's say, time, or they have no efforts would be justified to have different similar decisions if we could have one general decision addressed to all, so general statement of reasons. Specifically, when the decisions are based on huge administrative discretion, in many cases we have that for us, but not only for the person affected by the decision, but for us as controller, extremely important is to have detailed statement of reasons, because we cannot check whether the institution complied with law if they just have very general statement of reasons for a specific decision. And this also is certainly linked to the duty of care, on which we worked a lot with renewal, because the institutions, when they take decisions, they should investigate properly. And if they investigate properly, it means they also provide individual specific statement of reasons for their decision. But there are situations, for instance, which we hear something of this kind, and I am curious what you will think about this, because we could say, if the outcome of the process, administrative process, is general statement of reasons, this means necessarily that there was no individual assessment of the case. And we heard not only from administration, but also some judges with whom we have contacts, they tell to us that on many occasions, in the situation we have the many cases of the same kind, so we have the identical legal basis for these cases. We have identical circumstances almost, but many people involved. So the judges or administration takes one of these cases, a leading case, and then in other cases, they just make a link to the specific case and don't justify individually the decision. This would mean, for them, that this is because of procedural economy, they do so, but this could also perhaps mean that the right to have individual assessment is violated. This is an issue with which we have to deal on a few occasions. 2 minutes more, and now I will finish by perhaps concluding in 2 words. One thing which we cannot forget either, that the statement of reasons is also important to control the administration, to see whether the administration is open, it's transparent, because as you know, Article 298 of the treaty provides that European administration should be open, independent and efficient. As regards our cases concerning asylum and migration, we dealt with Frontex, we did with ASO. There are 2 agencies which are under our control, and the accountability issue, what we discussed today morning, is a big problem for us, for the European Ombudsman. For that reason, when dealing with cases, when checking individual assessment also, in a quite recent case against the ASO in admissibility interviews carried out in a Greek hotspot, we had to take a stance on individual assessment of migrants. But I am open for questions. Thank you very much.